Please be seated. All right, we will hear from the appellant and Marshall Ethridge against the Department of Revenue.
Morning, may it please the court. I'd like to reserve 3 minutes. Well, basically, we're here to ask the court to declare that the child support guidelines in its entirety are unconstitutional. And in this particular case, we have Marshall Ethridge, who has 2 children which are subject to the guidelines in this particular case. He has a total of 6 kids altogether. 2 of them in Georgia. 1 is on a support order in Georgia. He's married, and he has 2 children living with him at home. We take the position, Your Honor, that where the guidelines say to a person is that after Uncle Sam takes your money, then the guidelines are going to kick in, and we're going to take out child support. But Ethridge's argument is different from any argument that we're making and from anyone that I've found out here in terms of precedent. Is that Ethridge is saying to this court is that before I am required to pay child support, I should at least have an allowance for myself because I have to work, I have to live, I have to buy food. And if you take all of the money and give it to the child first, then there is no money left for me to be able to provide my own necessities.
Well, didn't the court find that they imputed income for him?
They did.
Which meant they found he could make more money if he wanted to.
Yes. In this case, Ethridge was, he still is a longshoreman. But because of an arrest that he had, he was in jail for 8 months. Then when he goes back on the dock, he falls down from where he was. He never had his actual seniority card, but as they call him a loafer or whatever they call him, but you can go and work every day. They provide enough income for you, and if you make 70 hours in a year, then you get benefits. But because of that arrest that he had, he lost his status with that particular union that he had, so he had to start all over again. Ethridge says in this case is that the working as an ILA longshoreman is one of the best jobs that you can have, because once you make those 700 hours, then you get the benefits for yourself. But if you make 13 hours, then you get benefits for the entire family. So what this case boils down to is there enough money to go around? And I suggest to this court that in order to make this thing work, you have to be able to say to the person, you must be able to have an allowance. I say to the court that there's a case called Eloise versus Eloise, and that's a 4th district case. And Your Honor, the Eloise case did not say that the guidelines were unconstitutional, but what it said was, and let me cite the case for the court. That's where it's found.
Well, don't the guidelines provide an allowance for the wage earner? I mean, it doesn't take, the guidelines never take all or even a half of the money that a person earns, unless there's a situation where the court finds that they are not earning what they could be earning if they made different choices about where work.
Well, Judge Roberts, what happened in this situation is that the guideline doesn't take all of the money, but in some instances it does. Because what happens is that the guidelines say on this table is that
Can't the trial court deviate from the guidelines for good cause?
Well, the deviation is only 5%. And under the subsection 11, where it has these 11 enumerated deviations, they talk about expensive or excessive medical conditions that you can pay. But none of those take into consideration the payer's direct living expenses.
So there are no circumstances under which the trial court could deviate by more than 5%?
Well, Judge, I haven't seen where they can deviate by more than 5%. I think in terms of some disability cases and where the guidelines are evolving into being fundamental fairness for all persons who are having to pay, because if it's out there, you can't do it. Then the court is not permitted to do it under the statute.
Well, now, as you see the problem with the statute, would that be fixed if the statute permitted deviations to take into account the types of factors you're talking about?
Absolutely. It could be fixed, because what it will allow it would allow the person as a loss, it says hard expenses and soft expenses. And it talked about what your hard expenses are, which is your mortgage payment, your car payment, electricity, gasoline, food, insurance, and those things. And as a result of that, then if the guidelines allowed the payor to be able to take these things into consideration, then that person would have sufficient income to live on first. Then what was left over, then he would be able to pay adequate amount of child support. The way the guidelines are set up now, it's almost a windfall for the custodial parent, because the income that comes from the non-custodial parent, it goes over into that additional household. So you have two households here that are supposedly or should be equal, but on the non-custodial parent, when he pays, it swings this way. So that means that person does not have sufficient assets left to be able to at least survive. And when you're on the first line down here trying to defend these things, when you go in, the court only looks at, and with the support hearing officer, they're only looking at gross income, the allowable deduction, and your net income. From that point, that's where the child support comes from. It doesn't consider, as you just asked, Judge Ben, it doesn't consider what the living expenses are to the non-custodial parent. And unless the court declares these guidelines in total unconstitutional, then they're never going to be able to have equal footing down here so that they can support themselves and then support the children. I cited in the brief chapter 39, which talks about basic necessities that a parent must provide for their children. And it talks about food, shelter, clothing, and medical. So with these conditions, the trial court below does not look at any of these things. All it says is they go straight to the guidelines. What are the guidelines amount? Once they establish the guidelines, the question always come out of the non-custodial parent is, I can't pay this. I can't afford to pay this. And I'm sure that the court is not oblivious to the diamond solitaires, all of the starter jackets, and all of the problems and all of the things, the Air Jordans, the $200 shoes. The non-custodial parent has to pay these things, because when it comes to the custodial parent, they do whatever they want to do. So unless we're able to provide some basic subsistence for the person who has to pay, then we'll never get to the point of having the child support guidelines fair and equal. I think the court right now, in this day and society, can look at gasoline. You can go to bed tonight, tomorrow they may be up a dime. To married couples, Your Honor, they can adjust. They're going to Yellowstone National Park, been planning for it for 3 years, but now with the economic condition, they can't go. So as a result of that, married couples can adjust their lifestyle. But with the person who has to pay the support, there's no relief. When everything goes up, it goes up. And to try and go into the court below and get a modification, it's like pulling hen's teeth. You just cannot get it done. So you're talking about, is the relief temporary for me that I'm asking for? And when the economic conditions get better, I go back in. But unless we have some type of a system to make it fair and equitable, we can't make it.
Well, now, it is possible to get a modification, isn't it?
Well, in order to do the modification, then you have to look at the income of the non-custodial parent as to whether that person has the ability to pay, and what is going to be the conditions of the custodial parent when you reduce the income. So we got a trickle downstream here, and lack of a better word, trickle down economics. So we got a problem here as to how do we solve the problem. In the case of, cite to the court, Lee versus Delmar, which is at 66 Southern 252, a 1953 case by the Supreme Court. And it says that if the right to work, you have a right to work, earn a living, acquire and possess property from the fruits of one's labor. And the court says that is an inalienable right. And if that's an inalienable right, then we think that the strict scrutiny should apply to this particular test, because that is a fundamental right that the parent has. So if you're working for industry, you earn the money, then it should not be first in time, first in right. take that back. It should be first in time, first in right. So if you earn the income, then you should be able to prepare yourself for tomorrow to go to work. And when you have to pay the child support, if you have to pay the child support first, and that's what we're asking here from Mr. Ethridge, is that he should be...
Can the legislature make the decision that a parent should take care of their children before they take care of themselves? Can the legislature make the policy decision, that's the policy of the state, that a parent has to take care of their children's needs before they start worrying about their own needs?
Well, if that's the case, then you're putting the cart before the horse, I think. Certainly I would think that, because in other words, the parent has to work. So if you work, and when you work and come home on Friday and you get the check and you put it up there, and if there's nothing left for you for Saturday, Sunday, and Monday all over again, when the first of the month roll around, you got to pay the light bill, you got to pay the water bill, you got to pay your rent, you got insurance. So the only way that the person can get to work, they have to walk, or they have to get some other way to get there. And when you find young men and women who have to pay child support, they no longer have the potential to have their own living quarters. They have to give it up, because once the child support goes into effect, there are numerous cases that the courts have held and taken all the money from a paying parent, with the exception of $200-300. It is impossible for a person to live without having sufficient assets to take care of themselves. The legislature have said in Chapter 39 that the responsibility is for food.
Who should pay for the children?
Well, I'm not suggesting that Mr. Ethridge should not pay, but it should be paid. He should pay based upon his ability to pay and to be able to provide for the needs of his children by himself. With the guidelines dictate the standard of living for the custodial parent and the child. Simply because it looks in the book and it looks in the table and says that this is how much you have to pay. And if the non-custodial parent can ill afford to pay that amount, he has to pay it anyway. There is no relief whatsoever. So when you talk about the deviations, surely it should be where you can deviate.
You're down below the 3 minutes.
Thank you.
If it please the Court, I'm Toni Bernstein, representing the Department of Revenue. My opposing counsel has already stated that if the statute allowed for more than a 5% deviation, that there would be no constitutional problem. I'm sure that the members of this panel are well aware that the statute does provide wide discretion to the court, and the court can deviate by more than 5% from the guidelines. The only requirement is that they make findings explaining why. If it's a deviation of 5% or less, no findings required. More than 5%, findings are required. This is a statute that provides the trial court with vast discretion. There are 11 enumerated considerations to deviate from the guidelines, one of them being in order to come up with a child support amount that's just and equitable. In this particular case, we have a father who earns $16 an hour and has chosen to work as a longshoreman, making very little money because he loves this job, even though it's not paying the bills, and he is lucky enough to have a wife who clearly is supporting him. But even if the court were to look at the record, they would see this man did not have exorbitant expenses. I mean, he and his wife, I think, paid $250 for rent. There just are not huge expenses here. The trial court imputed income to him, but to be clear, they didn't impute him at $16 an hour times 40 hours a week. They imputed him at minimum wage. This is a man who's clearly able to work, able-bodied. He could get a job making minimum wage. That's what his child support guideline is based on. He stands here and argues that the court should consider his support first. Well, I think he's forgetting that the custodial parent also has support, but, has to support themselves. I mean, if the court just looked at, the parents say they can't afford to pay child support, I mean, who would be supporting these children? There is enough discretion in the statute that if the father had presented evidence that he didn't have the ability to pay, the court could have found that he didn't owe support. They could have adjusted the support. But a review of the record shows that basically the only testimony that he put in about his inability to pay was that he stated that he could only afford to pay $80 a month in child support. I mean, there's just nothing below to show that he didn't have the ability. Opposing counsel argues that the NCP is subject to rising costs, the cost of gasoline, whatever. So is the CP. He asked this court to look at Chapter 39 and say that under Chapter 39, he's not required to pay any amount of support. 39 doesn't talk about what makes a good parent. It talks about what doesn't make a good parent, what parents should not do. And if the court were to say, okay, parents can just pay what they feel that they could afford, under 39, maybe the non-custodial parent would get away with it, but I can assure you if the custodial parent said, gee, this kid living with me, I've used up all the money on myself, I'm not going to feed the child, the state would be coming in and taking that child. I just, don't feel it's analogous to whether or not the guidelines are constitutional. I can get into some of the other arguments that Appellant had in his brief, but I've addressed them in my brief. I don't know if the court has any more questions for me.
Thank you, Ms. Bernstein.
And again, I think this, in terms of parent and child, is that parents should have their own obligation as to how they should be able to raise their children. To provide.
Counsel, you would agree, though, that in the proceedings below, the judge imputed income to your client based on full-time employment at the minimum wage?
Absolutely, yes.
And you would agree that a parent has an obligation to support its child?
Yes. There is no question that it is. But our contention is that if I can support me adequately, I can best support my children adequately. And I would ask the court to declare that these guidelines are unconstitutional. And I know that in terms of if you do that, then what do we do with the existing income deduction orders and support orders? I would suggest to the court that if these guidelines are declared unconstitutional, it revert back to the establishment date. That all child support, which are just paying arrearage where the children are emancipated, that those arrears are eradicated in toto. And where there are current support orders, is that to have them to go back and to readjust the support based upon the fact of the payors or the non-custodial parent ability to pay after he or she is provided with basic subsistence, then go in under Chapter 39 and say that we need to be able to provide together, custodial and non-custodial parent, the basis for support of these children. And I would ask the court that with the parameters that are set forth.
Mr. Williams?
Yes, sir.
Specifically, what provisions of the federal or state constitution do you feel like makes these guidelines unconstitutional? What do you think?
Article 1, Section 2, which talks about the basic fundamental rights of a person. So that's where our argument comes from.
Of the Florida Constitution.
Of that, yes, sir. And in terms of that, we're just asking the court that if these things are done, then we're talking about the total amount of the ability to raise children where you're going to have two parents, whether they are married or single parents living separate and apart, that they would each have a very good stake with their children, because you have mothers and fathers together taking care of children and providing for the needs, so that when things go bad and the economy is bad, then they can both adjust. When on numerous occasions and numerous cases that have been before this court, they talk about the needs of the child. As the child gets older, then the needs for that child, they vary. We're aware of that. But we think that when the two parents are together are determining what I have available for the child, then the child should be able to play sports, piano, if we can afford it. But if we cannot afford it, then where does the money come from?
Counsel, is it your position that the statutes in question treat non-custodial parents different than custodial parents in terms of the parents' support obligations of the child?
Yes, absolutely. That's it in a nutshell. It does. Because, in other words, that it does not allow the non-custodial parent to be able to live first and then support his child or children. And that's our position. Thank you.
All right, thank you, Mr. Williams. All right, we call now U.S.